Thank you for attending A Tale of Two Schedules, what DOJ's partial rescheduling of medical marijuana means in practice. The event is hosted by the Drug Enforcement and Policy Center at The Ohio State University Moritz College of Law. Before we begin, we have just a few notes we'd like to share with you. First, we want to draw your attention to the Q&A function at the bottom of the Zoom window. The chat is disabled, but you may submit questions at any time. Please note, however, that there is limited time available for Q&A during the webinar. Second, automatic closed captioning has been enabled for this event. To change how you view the transcription or to hide it, click Show Caption in the menu at the bottom of your Zoom window. Finally, this event is being recorded. The recording will be made available on our YouTube channel as soon as possible following the event. A link will be shared with all registrants via email as soon as it is available. Follow us at OSU Law DEPC to stay up to date on our research, programming, and future events. Thank you again for joining us, and we hope you enjoy the discussion. Doug?
Thank you so much, Holly, and thanks to everybody works with me at the Drug Enforcement and Policy Center for enabling us to put this webinar together. I suspect most of you who've joined us are familiar with and at least aware of the recent Justice Department order partially rescheduling marijuana from Schedule 1 to Schedule 3 under the Controlled Substances Act. And if you are aware of that, you probably had as many questions as I did about it. And one of the ways I figure these sorts of things out is to reach out to the brightest folks I know, and I feel incredibly grateful that they've joined us here today on this webinar. I'm going to introduce our panelists, then ask Triple Buckeye, Kat Packer, who also works with us at the Drug Enforcement and Policy Center, to provide a short overview, if that's possible, about what the Department of Justice has done and is in the works of continuing to do. Then we're going to hear from each of our panelists with a short overview of kind of their take on where we are and where we might be headed and what is valuable to be focusing on as a matter of policy and practice. And then I have some questions to follow up with so we can look at how this order and what's following it may affect the cannabis industry, state regulatory agencies, and ultimately consumers. At the end of the day, the one thing I am certain about from this discussion is we'll never resolve all the uncertainty that we have right now, or even begin to answer all the wonderful questions that many of you in the audience shared with us. I think we got more than 6 dozen questions and are kind of continuing to think through and work through which topics and subtopics to perhaps do additional programming on. I welcome folks to use the Q&A to add questions, but I'm absolutely certain we're not going to be get to them all, and that's why we're having this first kind of overview panel discussion to just try to take stock, understand what we can, and map out how to think about and continue to ask questions about where we are with national federal cannabis policy and its impact on all the state reforms we've seen in recent years. So with that overview of what we're going to be overviewing, let me introduce the panelists in order that they are listed on your program, so to speak. We've got Professor Sam Kamin, who's the Chauncey G. Wilson Memorial Research Chair at the University of Denver Sturm College of Law. We also have Professor Robert Mikos, the LaRoche Family Chair in Law at Vanderbilt University Law. Then we have Kat Packer, who I mentioned. She's not only the distinguished cannabis policy practitioner in residence here at the Ohio State University Drug Enforcement and Policy Center. She's also the director of drug markets and legal regulation at Drug Policy Alliance. And many of you may know that she previously was the executive director of the City of Los Angeles Department of Cannabis Regulation. And then we have an active regulator joining us as well, Catherine Cornelius, who serves as Deputy Chief Legal Counsel for the Ohio Department of Commerce Division of Cannabis Control. And I guess I should have introduced myself. I'm Doug Berman. I help direct the Drug Enforcement and Policy Center here at the Ohio State University Moritz College of Law, and really honored and excited to be able to hear from the folks we've gathered today. And so, as I mentioned, we're going to start with Kat. Good luck, Kat, in short order, kind of reviewing or summarizing where we are and where we may be headed, but very excited to hear your take. And I know the Drug Policy Alliance put out a great document that gave us as viable a few pages of overview, but there's so much going on, and eager to hear what you're thinking about these days as you provide an account of where we are and where we're headed.
Thanks so much, Doug. I appreciate it. Thank you to the Drug Enforcement and Policy Center for putting this programming on and continuing to lead programming throughout the rescheduling process, I'm going to spend a little bit of time walking folks through how we got here, what is in the final order, and a little bit about what's to come. And then I'm really excited to get into conversation about related policy and regulatory implications with the subject matter experts that are joining. So as background, this final order that came from the Department of Justice and DEA in April of this year is a continuation of a process that started under the Biden administration in October of 2022, where President Biden directed federal agencies to review how marijuana is rescheduled, or how marijuana is scheduled under federal law. We saw that in August of 2023, Biden's Department of Health and Human Services recommended that marijuana be moved to Schedule 3. And in May of 2024, President Biden's Department of Justice issued a proposed rule consistent with HHS's recommendation. This proposed rule included an opportunity for public comment. There was a 62-day public comment period where over 43,000 public comments were submitted. This proposed rule also included a process by which individuals could request a public hearing on the proposed rule. And later in August of 2024, the DEA decided that there was going to be a hearing and selected an ALJ, an administrative law judge, to oversee said hearing, and identified 25 witnesses to participate in the hearing process. These hearings were scheduled to begin in January of 2025. However, there were allegations of improper behavior on part of the DEA, both in their communication with witnesses that were selected and in their selection of witnesses. And the process was ultimately stalled due to legal challenges to allow for an interlocutory appeal to the DEA administrator. Ultimately, the ALJ that was presiding over this hearing ended up retiring, and the process essentially sat on ice until in December of 2025, we saw President Trump issue an executive order called Increasing Medical Marijuana and Cannabidiol Research. And in this executive order, he instructed his agencies to expeditiously complete the process to move marijuana to Schedule 3. It's also important, I think, to go over some of what's in the final order and some of its related components. I'm going to spend a little bit of time doing that. The final order itself was announced on April 23rd of 2026. And importantly, the announcement articulated that the DEA was immediately placing both FDA-approved products containing marijuana and marijuana products regulated by a state medical marijuana license in Schedule 3 of the Controlled Substances Act. The announcement also clarified that there would be a new hearing that was to take place beginning on June 29th of this year to consider the further and broader rescheduling of marijuana. And there was essentially a clarification in the notice that the DEA was withdrawing the original hearings and notice of hearings associated with those that were supposed to start under the Biden administration in January of 2025. So this order that immediately placed these two specific categories of marijuana in Schedule 3 did so in part by heavily relying on a specific provision within the Controlled Substances Act that's generally referred to as the treaty exception, 21 USC 811D. And this particular provision of the Controlled Substances Act allows the Attorney General to bypass the normal rulemaking process and the findings and procedures that are normally required under a scheduled rulemaking process if a particular drug is subject to control under the international treaties. This provision essentially allows the Attorney General to place that drug in the schedule that they deem most appropriate to carry out the functions of the treaty itself. So the final order itself relies on that specific provision in order to immediately place marijuana in Schedule 3 without a continuation of the normal rulemaking process that would include the hearings that are taking place for the broader rescheduling of marijuana. Importantly, the order itself walks through the U.S.'s treaty obligations and spends time walking through various existing, does a coverage and overview of existing state regulatory systems, and then describes its authority to place these particular products in Schedule 3. Notably, the order also discusses related tax implications, requirements for handling FDA-approved products containing marijuana, describes a registration process for state licensees, provides regulatory analysis, and includes updated codes of federal regulations related to these particular products that have been rescheduled. Importantly, only 2 specific categories of marijuana have been rescheduled. Again, FDA-approved marijuana drug products, and then marijuana products that are coming in any form covered by a state medical marijuana license. The order specifically articulated also a number of categories of marijuana products that are excluded from being impacted by the order. Specifically, unlicensed bulk marijuana, marijuana extract, Delta-9 THC material used to make FDA-approved drugs, and synthetic THC remain in Schedule 1. Hemp and the definition of hemp remain unaffected by the final order. And any product that was previously rescheduled or that contains marijuana or THC that had been previously rescheduled out of Schedule 1 is not impacted by the final order. So, for example, Marinol and Syndros. The order broadly not only articulates what products are now in Schedule 3, it articulates the registration requirements for these 2 categories of products. Registration is required for those who want to lawfully handle marijuana under the CSA and in compliance with Schedule 3. So the order walks through what the various registration requirements are for individuals seeking to handle these products. But importantly, it also creates 2 distinct regulatory pathways, one for individuals who want to go the FDA-approved route, and then another pathway for state medical marijuana licensees who seek to register with the DEA. This is notable in part. There are 3 types of registration that are available for operators. There's a manufacturer registration, a distributor registration, and a dispenser registration. I'm sure we'll get into some of the components and requirements of both categories of product handlers, but I'll just start by articulating that this registration process that's available to state medical marijuana licensees, the order specifies that there is an expedited pathway for review, particularly for individuals who applied within 60 days of the application being available. And the order essentially says that if you apply within these 60 days, the DEA will review and process your application within 6 months, and operators can continue to operate during the pendency of their application review. What's also important, I think significant about the registration is that it is specifically tied to the state authorization, essentially meaning that the registration itself is only authorizing activity that is authorized through the underlying state license. The order clarifies that essentially the federal registration process is relying on some of the state regulatory components in lieu of what would other be specific handling requirements. The order also, I guess I'll say the announcement also articulates that there is going to be a hearing that is going to take place on June 29th. There was a process by which individuals who are seeking to participate in the hearing could submit a notice to participate in the hearing. The DEA is supposed to notify individuals who have been selected to participate in this hearing by June 22nd. And the hearing is scheduled to conclude by July 15th. And so we are in many ways expecting at least a continuation of this conversation in short order. And I'm sure there will be ongoing opportunities to provide timely updates as this process continues. But Doug, I want to hand it back over to you now. And we can.
Well, I want to thank you for taking on the otherwise thankless job of sort of laying the table and providing some background. I know all of our panelists have a variety of takeaways from just what the lay of the land is, but I first want to give folks a moment or two if they want to sort of chime in with any additional kind of baseline background comment. Again, impossible to cover everything that was in that order and the upcoming hearing and all that surrounds it. I know there's been litigation, though I can't even keep track of various filings to contest both the order and what's supposedly coming with this hearing. But Rob, Sam, or Catherine, I don't know if you want to chime in, or we can just shift to the takeaway segment, and that's perfectly fine because I'm sure we'll get some coverage there. So, not seeing any hands up, Sam, why don't I just punt it to you to give your kind of view of the world, as it were.
Thanks so much, Doug, and thanks to you and Holly and all the folks at The Ohio State University for putting this together. It's always a pleasure to talk with folks that have been talking about this stuff now going back more than 10 years. And this is a great forum for us to learn from each other and to hopefully create a little knowledge and send it out into the world. I also really want to thank Kat for that overview. As Doug said, it's a thankless task to try to make sense of what happened in April with Acting Attorney General Blanche's notice or final order. And I'll just sort of take a few professorial potshots at it, and then I'll look forward to continuing the conversation once everyone has had a chance to speak. I'll just sort of start by saying I thought when it came out that the reliance on the treaty power, which is how this is really framed and where it begins, doesn't make a lot of sense and is not a good rhetorical strategy for the Attorney General if the ultimate goal is a more complete rescheduling of marijuana. In the very first paragraph of the order, Acting Attorney General Blanche says, well, I'm required to do this by our treaty obligations. And I just don't believe that that's true. Those treaty obligations have been in place for decades, and there is no immediate pressing concern to change U.S. policy to conform to them. And just completely editorially add, coming from this particular administration, the idea that, well, we are completely bound by our treaty obligations. That's the most important thing. That's more powerful than federal law. While constitutionally correct is certainly a little jarring. As a rhetorical device, it doesn't make a lot of sense in that in order to comply with the treaty obligations, it will certainly be very hard for the administration to argue that recreational or adult use marijuana should also be a Schedule III drug, given the treaty obligations to make these drugs available solely for medical and testing purposes. That's just sort of a non-starter from a treaty point of view. It under domestic law, I think there's a strong argument to be made there, but under the treaty requirements, I think it's a tough one. Second, the Attorney General, or currently acting Attorney General's order creates a very nonsensical, complicated, and ultimately impossible status quo where the same marijuana that's on shelves in Colorado or California or Ohio is treated very differently whether someone walks in with a doctor's recommendation or not. Here in Colorado, we have lots of stores that sell both adult use and medical marijuana. If they're selling that same product, I want to emphasize the same product in the same package to someone with a medical recommendation, they're selling a Schedule III drug. If they sell it to someone who walks in off the street without a doctor's recommendation, they're selling a Schedule I drug. It is the same drug in the same package, but it is treated very differently by law in a way that isn't sort of justified by the chemical makeup of the thing that's being sold. So that's weird. It's unstable. It's not forward going. And then the question sort of comes, and I'm sure we're going to spend a lot of time today talking about, is this a 2-month problem or is this a forever problem? That is at the end of the hearing that Kat discussed, assuming it happens, assuming it doesn't get derailed by the litigation that Doug talked about. At the end of that, will all of marijuana be Schedule III? Will it all be outside the Controlled Substances Act? Or will we continue to have this split between adult use and medical marijuana that has enormous implications for people in the industry? It has enormous implications for regulators. Maybe less for consumers, though it may have big implications for the price and availability of different products. I know Rob is going to talk about this, so I'll just touch on it briefly. It's also important to remember that the product that's being sold in so many of these stores in so many of these states is not an FDA-approved medicine. There is no FDA-approved medicine where you set fire to something and breathe the smoke from it into your lungs. That is very unlikely to be approved as an FDA-approved drug anytime soon. So even a move from Schedule 1 to Schedule 3 will not make the sort of selling of flower for smoking into an FDA-approved drug, which has all sorts of implications that we can get into. And I guess I will stop here, though. I could go on. I know we all could go on for quite a while. I see Doug appearing probably to tell me to shut up. I'll just sort of talk about the Ouroboros problem as I describe it, which is, the Fed said marijuana is prohibited. The states said, many of them, most of them said, we don't think it should be. The Fed said, okay, we'll defer to you. And now they're the sort of the snake chasing its tail of who the regulator is, whether state or federal law predominates. That's clear in so many areas of law is not clear here. Doug, I'm shutting up.
No,
I look forward to the discussion.
You came to the nuisance because I thought you were wrapping up, but I appreciate that I know you wrote one of the leading articles early on about I think you called it cooperative federalism in this space and the opportunity for a kind of state-federal partnership that arguably it's surprising that this administration is sort of doing it kind of maybe and who the heck knows, but absolutely a set of broader just structural questions about how policy is getting made in this space in general against the backdrop of what has historically been sort of federal dominance. And so I know Rob's written about that as well, and so we will kick it to him. Thanks, Sam. We'll get back to you for sure along the way. Go ahead, Rob.
Well, thanks so much for including me, Doug. I'll just riff a bit on what Sam was getting at kind of through his remarks, and that's that the bottom line, the impact for companies that are licensed by states to sell marijuana, the impact of this rescheduling action, I think, is going to be very modest. Even for those companies that are operating just in the medical marijuana market. And there are several reasons for that, but one of the key ones is one Sam briefly mentioned, and that's that everything these companies do is going to remain unlawful because the Food, Drug, and Cosmetic Act, a second key statute that governs drugs, that's been kind of in the background for the last several decades, that statute is going to continue to forbid the sale of marijuana, notwithstanding rescheduling under a different statute, the Controlled Substances Act, and notwithstanding legalization or authorization under state law. So the Food, Drug, and Cosmetic Act, in a nutshell, it prohibits the marketing of any drug that has not been approved by the FDA. And as Sam hinted, there's nothing in the acting attorney general's order that confers FDA approval on marijuana. In fact, the only botanical cannabis product that the FDA has approved, that's Epidiolex, which arguably isn't even marijuana anymore with the reclassification and redefinition of hemp. So there's no botanical marijuana product out there that has gotten FDA approval. Hence, under the separate federal statute, it's going to remain unlawful under the Food, Drug, and Cosmetic Act to market and sell this drug. And that's important because a lot of the headaches that the state licensed marijuana industry now faces, it stems not so much from the CSA itself, or not uniquely from the CSA, but from the fact that what they're doing, all their business activities, are unlawful under federal law. For example, it's difficult to, impossible, in fact, to register a trademark with a federal PTO because you're not engaged in lawful commerce. Well, that will remain true, notwithstanding rescheduling, until marijuana actually gets FDA approval. Likewise, banks are leery of dealing with companies in this industry because all their activities are unlawful, and therefore, arguably, every transaction involving the money from this industry implicates the bank in money laundering. So as long as the activities of this industry remain unlawful, they're going to continue to face a lot of the same headaches they've faced historically. And it's important in this context, marijuana is going to be a very unique drug under the CSA for a couple of reasons. One is, as I mentioned, this is going to be a drug that is chemically identical, but placed on two different schedules, either Schedule 1 or Schedule 3, depending on its intended use. There's no other drug that's like that. So this is unprecedented to place the exact same chemical substance on two different schedules under the CSA. It's also unprecedented to have a drug on Schedule 3 that has not been FDA approved. Normally, rescheduling would follow only after FDA approval or something akin to FDA approval. Other drugs that you might hear about on Schedule 3 right now, like ketamine, those have gotten FDA approval in the past. So the companies that make and sell ketamine, they don't have to worry about violating the Food, Drug, and Cosmetic Act as long as they comply with all of its strictures. But that won't be possible for marijuana companies because the Attorney General hasn't, and the Attorney General couldn't confer FDA approval on this drug. It's going to take a lot more research, a lot more randomized controlled trials to actually do that, to convince the FDA to approve any marijuana product. So that means that the benefits, the practical benefits to the state licensed medical marijuana industry, they're really going to be limited to the tax front. When the acting attorney general rescheduled medical marijuana, he arguably gave companies that sell medical marijuana a reprieve from that dreaded Section 280E of the tax code. That's the weird provision that forbids companies that sell Schedule 1 and Schedule 2 drugs unlawfully, forbids them from making all sorts of deductions when they calculate their federal tax liability. So going forward, companies in the medical marijuana industry no longer need to worry about Section 280E. That's meaningful. That's a financial benefit to them, but it's not a full reprieve from all the headaches that are caused by federal law. And it's also important to recognize that this limited benefit, this relief from Section 280E, it actually applies to only a very small segment of the overall state licensed marijuana market. In states that have both a licensed medical market and a licensed adult use marijuana market, that medical marijuana market comprises a small and shrinking share of the total. In Colorado, for example, I think the medical marijuana market right now accounts for only about 10% of all sales. So it's really only about 10% of the market that's going to have any benefit whatsoever from the acting attorney general's order. So I think we just need to be realistic about the impact of this move.
Thank you so much, Rob. And I'm going to actually turn to Catherine now to get kind of the state regulator perspective, and maybe she can even speak to, if she has handy, the medical versus recreational story here in Ohio, but more generally, I guess, talk about thankless jobs, folks who have to deal with balancing all these issues at the state level while the feds are, I don't know if you can speak to or have any basis to tell us that there's been any effective communication from the federal government to state regulators about what all this should mean and how it impacts existing state regulations. But Catherine, I suspect you've been in the eye of the storm in various ways, not just because of the April order from the acting attorney general, but just the range of uncertainties and questions that arise, given that federal state interplay. So I want to give you a chance to speak to what's happened and how you're thinking about where we are and where we might be headed.
Well, thank you so much. I appreciate it. And thank you for asking me to attend. It's an honor to be here. I would say that first and foremost, while I would love to come to this panel and provide, answers to all of these wonderful questions and provide further guidance and communication, at this time, the state of Ohio really hasn't had any clear guidance or feedback from the federal government. And here in Ohio, we have a very interesting, I think it's similar to other states, but here in Ohio, we are truly dual licensed entities. And so each one of our licensees to us truly are both a medical as well as a non-medical licensee until the point of sale. I know that our licensees as well as the public have been requesting our position on how we will address that. Ultimately, frankly, the state of Ohio needs to acquire better and more direct feedback from the federal government before we're able to really take meaningful next steps and answer some of those questions. Again, I would just say that working in this industry and working as a regulator, I think someone described it as weird, uncertain. Frankly, we have existed in a situation here in Ohio where we haven't had any kind of federal preemption or federal guidance. And now we're kind of incorporating that within our next phase as a division. But truly, unfortunately, I don't have great answers or a lot of answers to any of the questions. And it's something that we are internally struggling with as well. I would agree with some of the folks' representations that, from an overarching policy perspective, I suppose not a significant amount will change. However, I can say that on the ground here in Ohio, we are contemplating and trying to think of every permutation on what we would need to update, what we would need to address. Again, licensing is the biggest issue. whether we would have to, reissue or do another licensing event for medical licenses only is still to be determined. Additionally, right, our regulations apply equally to both non-medical as well as medical licensees, as well as cannabis. And so we are also faced with uncertainty as to whether we will need to once again amend our rules to address this new impact. One thing I also kind of wanted to piggyback that I think that Rob mentioned was the 280E impact on taxes. I would say that hopefully will have a positive impact on the industry, right? Folks and licensees cannot get traditional lending. That creates a myriad of issues that we see at the division from ownership, financial interest perspective. But I agree, ultimately, I think a Safer Banking Act would be necessary to open the door to more traditional lending and loan options. But again, I'm happy to answer any specific questions, but unfortunately at this time, Ohio doesn't have a lot of great answers for folks, but we hope that everyone knows we're trying and we hope to provide as much communication as we can. And we appreciate everyone's patience while we all work through this.
Thank you, Catherine. I want to make sure everybody knows how lucky we are to have the Deputy Chief Legal Counsel from the Ohio Department of Commerce, Division of Cannabis Control, sharing, the uncertainty and explaining where they're at. I guess I don't know if even this is a question you can directly answer, but it's sort of implicit in some of the comments you already made. Do you sense that players in the Ohio cannabis industry are reaching out to you to try to get some kind of documentation or verification or blessing that a certain percentage of their sales should qualify as medical? Rob mentioned, and we'll talk some more about the tax implications. You mentioned it as well. And so I could see the industry having an incentive to just try to continue its practices, but make sure as much of its work can be categorized as, in a sense, Schedule 3 activity so that it can benefit from the better tax treatment. Is that something that industry players are reaching out to you, trying to get your help with? Are they just looking for guidance, or are they actually looking for, some kind of official Ohio state stamp of approval that enables them to then make certain representations with respect to tax? And I'm not sure if somebody mentioned this already. Maybe Kat, you want to speak to this as well. The order, as I recall, hinted at the possibility that there could even be retrospective tax relief so that medical companies that had been doing this work for a while, and of course, Ohio had a medical only program for a number of years before voters enacted a complete adult use program. Are they looking to get documents from you for that, or some kind of is that an aspect of what is part of the public input, or is it just everyone's still trying to just figure out where things land and they haven't gotten to that point?
We receive a lot of inquiries from our licensees, from lobbyists, from attorneys, the public, right? And when we discuss this internally with the superintendent and deputy superintendent, right? Realistically, we can't take a position right now, right? So we have been asked to provide letters of good standing, determinations, right, on, this is medical until a certain point in time. Again, the way that we treat our licensing here in Ohio, to us, everything is non-medical and medical until point of sale. And there's only a very small difference in certain products. So we would love to be able to provide, some sort of feedback. But again, until we understand, unfortunately, our risk, right, our liability, because we do regulate a federally illegal substance. Until we have further guidance, we've just taken the position, unfortunately, that we can't provide that official clarification or position. And it's unfortunate because we would love to, and we would love to be able to assist in any way. And it's a new world that we're living in.
Very, very much appreciate that. And thank you, Kat. I'm going to bring you back in and both, see if you have a perspective on how this is working nationally, knowing you're connected to regulators across the country in your role, and also thinking that you may have some insight as to what we can expect at this hearing. I heard something to the effect of we're not even sure that there's a judge to preside over this supposedly happening in a couple weeks hearing, and just, maybe you can give us some more where I think all talking about, it's in the title of this program, this sort of two schedules, this two steps that we may be taking with some rescheduled product already, and then a hearing to consider rescheduling more generally. But is that really going to happen? And is there a vision of, not a path to more certainty, but at least the possibility that we're going to get a little bit more regular order if a hearing goes forward, and what comes of that?
Yeah, thanks for the question. One would hope for more guidance. I believe I've had lots of conversations in the last several weeks with different cannabis regulators across the country, and I think that they're similar to Catherine, struggling to answer questions, feeling like they're not in the best position to interpret or translate what this means on behalf of the DEA to their individual operators, and there is an ecosystem of confusion that exists. I think that, of course, regulators would want to be in a position where they could help support their operators and give them, information that is accurate. But most conversations that I'm having with cannabis regulators across the country, they have way more questions than answers. And I'd hope for guidance. I don't know that we should expect it. And it would be helpful that that guidance be timely, in part because, as I had mentioned, the final order articulates that there is this expedited processing window in which individuals can apply for their registration, and the order articulates that there's an ability for those individuals who apply during this process to continue to operate. But it leaves the question of, well, what does it mean for everyone who is unable to apply within that window? Are they supposed to cease operation? What are the related enforcement implications? It seems as though there was at least clarification recently that the DEA will continue to receive applications for DEA registration beyond that 60-day window. But I think that this whole process has left a lot to be desired in terms of understanding what the ramifications are just of participating in the process itself. But then what are the actual consequences of these state medical marijuana licensees also being DEA registered? Lots of debate around and amongst subject matter experts around various types of implications for different stakeholders. The order itself is focused on essentially what businesses need to do in order to handle and kind of legally both to handle the Schedule 3 products and to legally comply with Schedule 3. But I talk to lots of stakeholders, beyond folks in the industry, patients, consumers, government officials, policymakers, who are asking the question, well, what does this mean for patients? It should logically follow that if patients are utilizing products that are now Schedule 3, that their use, at least in some form or fashion, should be considered lawful, and we would hope that there would be an extension of rights for patients who are utilizing Schedule 3 cannabis consistent with state law and consistent with Schedule 3. But there's no guidance from the federal government, and I think that puts individuals and communities in a very tricky spot. My concern throughout this process, in part, has been that I don't want folks to think that they have rights that they don't have, and then they go out and try and exercise those rights. And I continue to have concern about the lack of guidance and the lack of public education that one would expect from such a robust change in such an unprecedented fashion at the federal level. And so I do think that there are significant implications, potential implications across the board, but those implications largely, at least for me, lie in the many stakeholders who are left behind by a decision like partial rescheduling. I'm somewhat confused as to how in this process we got to this narrow rescheduling of just these two categories of products when throughout the process, since the start of the Biden administration's launch of the review, we've been talking about marijuana and cannabis in its entirety. You know, the HHS's analysis wasn't on these two narrow categories of products. In fact, there was an explicit consideration of adult use cannabis as a part of marijuana, as a part of this review process when DOJ and DEA under the Biden administration issued their proposed rule. It wasn't a proposed rule to move these specific categories. It was a proposed rule to move all of marijuana. And so I think for me, that leaves questions about what we should actually expect at this hearing. I've at least mapped out three potential realities. One is that we get through this hearing and there's no change. We just ultimately end up with these two categories of marijuana that had been previously rescheduled because of the April order. We end up with, or two, we end up with all of marijuana being moved to Schedule 3, as was a part of the original proposal. Or a third option is that we have something more than what we have in terms of the partial rescheduling that we have today, but much less than a full, complete rescheduling of marijuana under the CSA. And those details will matter legally in terms of how folks across the board are treated under federal law. I also just want to mention that I see this partial rescheduling as widening existing racial disparities that exist in the cannabis industry across the US, in part because we know that there were high barriers to entry in medical markets. Often medical markets explicitly excluded individuals with past cannabis criminal histories, and that it's largely been through adult use programs that there have been a number of initiatives to allow small minority, veteran-owned, women-owned businesses to come and participate. And because this is limited to medical only, that in and of itself is going to allow a certain category of stakeholders to reap privilege and benefit. And then it's also important to note that the registration process itself is asking for information about whether or not individuals previously engaged with activities associated with controlled substances or have criminal histories, and with kind of no question about the reality of the fact that there are many programs who support individuals with criminal histories participating in the industry. And so I think that there are lots of questions that remain, but the implications are real. And that's part of the reason why organizations like the Drug Policy Alliance have continued to articulate that rescheduling is not enough, and that in order to actually address this issue directly, we need to deschedule marijuana and remove it from the Controlled Substances Act and regulate cannabis like we do other products for adults.
Thank you so much on all those fronts, Kat, and you got a lot in there, which is helpful. I want to definitely open it up to the other folks on the panel to speak to any of the specifics they'd like to, but I especially want to get into what we might expect from this upcoming hearing. And you mapped out the idea we could be stuck with the status quo, although I assume going backwards is a possibility legally, if not a practical expectation that you could have this hearing and that could lead the acting attorney general or others in the administration to say, no, we made a mistake, even allowing a partial rescheduling, though, again, maybe Rob, you know if that's a possibility, but then the keep what we've got in place, expand somewhat the number of products that are in Schedule 3 or entirely shift marijuana into Schedule 3. I assume not on the possibility list. I think this is a matter of existing law to deschedule through the administrative process. I assume there could be scheduling down to Schedule 5 or other scheduling choices if we're just going to essentially, freehand this. But I think you're right that I certainly think that the three options you laid out seem most likely. I'll start with you and then shift to Rob and Sam to jump in as they see fit. And how long would that take? What's the usual timeline here? I know we're under all sorts of weird executive order to expedite and uncertain things going on along the way. I've seen close to the effect of a year to 18 months would be kind of the reasonable expectation of when we get some result from the hearing. But do you or Rob or Sam jump in as well? Basic timeline and then what that looks like at that moment.
At this point, I'm crystal balling, but what I will articulate is that the process is not time bound. And so, we could get through a hearing, the ALJ could compile their record and transmit it, and then it could sit with the agency for however long. And then at the end of the day, you kind of regardless of what's in the record, the decision is still at the complete discretion of the DEA administrator. And so while I think would be unprecedented for the ALJ to recommend and articulate one thing and the DEA and DOJ to do another, I think we're in the realm of unprecedented action.
Rob or Sam, either you jump on in.
Yeah, I think substantively, I don't expect the DEA to broaden rescheduling to include, for example, adult use marijuana. I think the DEA will ultimately say, we're just going to stick with what the acting attorney general has already done. And part of the reason for that is that the excuse that the acting attorney general gave for stopping short for rescheduling only medical marijuana, he said, well, I can't go any further because international law doesn't allow it. I think Sam's absolutely right to be skeptical that the attorney general or Trump believes that, actually cares about international law. But even more importantly, if that constraint really exists, it applies to the DEA as well. Basically, the DEA in the past, in fact, has said, our hands are tied. We have only limited amount of wiggle room to reschedule a drug like marijuana because if we reschedule it any further, if we push it down to Schedule 3 or more, it'll violate our treaty obligations. So I think what the acting attorney general was really doing in rescheduling marijuana was kind of trying to throw a bone out there and appease some of those who are demanding rescheduling, keeping open the hope or alive the hope that maybe the administration would go further, but also kind of laying out the argument for the DEA to use as its own excuse to say, hey, the acting attorney general said we can't go any further because we'll be in violation of the treaties. The CSA doesn't allow that, so we're stuck with rescheduling of medical marijuana. And it's also important to point out that executive order that Trump issued back in December, the one that called for expedited rescheduling, it specifically only mentioned medical marijuana. It said, I want the expedited rescheduling of medical marijuana. So I'm not even sure Trump wants to do this. And I think that the fact that he's come up with this excuse under international law is consistent with that. He doesn't really want to push it any further, but he didn't want to say no quite so soon. So this is a way to kind of do both things, but I don't think the DEA is actually going to follow through and broaden this at all.
Yeah, I'll just follow up on that real quickly. I think I agree with my friend Rob. The Blanche order reads as I'm obligated to do this and forbidden from doing anything else, which does raise the prospect of us staying in this bizarre same drug to regulation space for a while. And I think I want to make sure we get to some of the questions that are getting asked, but it does raise this question of if you are an operator in a state that permits both medical and adult use marijuana, if you think this is a 2 or 3 or 5 year status quo, I know and I agree with Rob that medical makes up a small percentage of the industry at the moment. This is going to create a lot of pressure for someone walks in who's a recreational customer. it will be much more advantageous for that operator to sell them medical marijuana than adult use marijuana. And so they'll create, incentives, whether, legal or formal or not, to make that person a medical patient so that they can take advantage of 280E, take advantage of banking, take advantage of some of the changes that are coming for medical if recreational or adult use stays as Schedule 1. And I really think that could really change the status quo in ways we can both anticipate and not.
I think that's a really important point that, we've been talking around in a variety of ways, but indisputably the current uh, order in a variety of ways preferences medical product. And as a result, whether and how existing markets and players shift accordingly. I will put one more, especially a question that's in there. And does that extend to interstate commerce? Is your understanding, with the existing order and or if it gets put in place, permanently after a hearing, that this would allow Schedule 3 operators, I'll just sort of call them that, to transport their Schedule 3 product across state lines? One of the things that has defined marijuana reform in the states has been the state-specific siloing that's been necessitated by federal Schedule 1 status. And there obviously are a number of significant multi-state operators, but they have to stand up their operation within state to avoid those problems. Does that also melt away? We've talked about the tax issue. That's obviously could be very consequential to operators in states that can benefit from the tax relief. But is the interstate commerce opportunity, which presumably could mean producing product in whatever state is the cheapest to produce it and then shipping it to all affiliates and even not just individual operators, but selling to other operators across state lines, is that on its way? Is that unclear whether this partial rescheduling enables that? Is that another thing? I don't know, Catherine, if you've gotten questions about that from your industry players, but I think it's one that seems to have the most potential to change the existing industry realities beyond the tax question. And I'm curious if anybody has views on that.
I'm happy to be the guinea pig and start the Dormant Commerce Clause conversation. For folks who know me in my real life, this is one of my favorite topics to talk about. So we are seeing some of that litigation, I think, cropping up within the hemp industry here in Ohio. So my understanding is that we will probably garner additional litigation and claims for Dormant Commerce Clause issues by multi-state operators. Specifically, we're planning and have an eye out for assertions of regulations and policies that are unduly burdensome, right? A lot of our advertising as well as our packaging and labeling regulations are geared towards child resistance, right? And preventing, inadvertent consumption by young children. My understanding, and again, I would like to hear from the scholars on the call if I'm wrong about this, but my understanding is that there are Dormant Commerce Clause claims that could occur based upon the differing regulations between states. And so we're preparing for that. What we try to do at the division is look at multi-state comparisons on how folks implement policy across the United States. We try to harmonize our policy and our rules where possible. However, again, thus far, states have, generally speaking, within marijuana only been sued for Dormant Commerce Clause issues as it relates to express in-state provisions, right? Like you're an owner and you shall be an owner from Ohio if you want to own a cannabis company. So I don't, and again, I could be incorrect on this, but I don't think that thus far there's been substantial litigation on that front, but I assume it's going to be an issue going forward.
Go ahead, Rob. I know there's nothing like the Dormant Commerce Clause to get this crowd excited, so go ahead.
This obscure area of constitutional law. The most vulnerable state laws under the Dormant Commerce Clause are state laws that discriminate against out-of-staters. So as Catherine mentioned, lots of states have laws saying you have to be a resident if you want one of these valuable marijuana licenses, a license to run a marijuana business here. And there's actually been a lot of litigation in the last 5 years on that question. The problem is that the circuits are really split on it. You get some circuits, I think they're in the right. The First Circuit, for example, has said, yeah, the Dormant Commerce Clause applies here. And states can't discriminate against out-of-staters. But then you get some other circuits like the Ninth Circuit that says, no, we think that the fact that Congress has banned this product turns off the Dormant Commerce Clause. So now what do we do in a world where, well, at least some federal law has changed? Is it legal enough so that these circuits like the Ninth Circuit will now say, all right, Dormant Commerce Clause applies? We don't know. I think my answer early on that marijuana, the sale of marijuana still isn't going to be legal. It'll still violate the Food, Drug, and Cosmetic Act. Maybe that will hold sway in those courts that say Dormant Commerce Clause doesn't apply if the activity is unlawful. So you may continue with this weird circuit split where in some parts of the country, states aren't allowed to discriminate, other parts they are. I know there's an effort afoot to get the Supreme Court to weigh in on this to kind of settle the question and level the playing field here one way or the other. But I just don't think rescheduling necessarily moves the needle that much just because it's still all going to be unlawful, just under a different statute. So the analysis of courts like the Ninth Circuit really doesn't change.
But I'll chime in with the follow-up question, Rob. But even if there's not a constitutional argument for demanding the possibility of interstate commerce here with cannabis products, is there just hey, now that it's Schedule 3, there's nothing that precludes me from wanting to take medically authorized material and move it from one state to another because, I can move other Schedule 3 drugs that way without running afoul of federal law. Now, again, I guess there's the extra complication of we don't know if something that's medically approved in Ohio is medically approved in another state. And so I guess you could still build out that argument even under the existing order. But if we had a blanket Schedule 3 order that says all, medically approved products are for all, purposes Schedule 3 permitted, does that enable these industry players to start moving product across state lines?
Not necessarily. And the reason is nobody cares about the DOJ. The DOJ could arrest you if you were growing and selling marijuana entirely within the confines of Columbus. It's all unlawful. So you don't really worry about federal enforcement. There's not much of it. What you have to worry about, though, are states. And if states continue to ban the free flow across state lines of marijuana, I think companies will probably refrain from doing that because they might lose their own state license. They might get in trouble with state regulators who do have more resources, a little bit more clout, a little bit more influence over the industry.
Yeah, and I'll just add that we saw that with hemp, right? That people were trying to transport hemp, which was legal in Washington and legal in Colorado, through Idaho, and Idaho stopped them and said, "We think that's marijuana. We don't think that's." So the differences and diversity among state laws is going to continue to be a real challenge. I mean, there might be a product in Colorado, you're limited to 100 milligrams of THC per package. In another state, it might be more or less. And so a product that's lawful for sale or possession in one state might not be in another. That's going to continue to be a puzzle. I'll also just sort of remind us that the reason states did what Catherine was describing, requiring citizenship for ownership, placing limits on out-of-state sales and shipment, was to avoid the federal enforcement that Rob was talking about, right? That during the Obama administrations, there were memos that said, look, these are our priorities, and that among them was the diversion of marijuana, lawful in one state but unlawful in another. A lot of those rules were put in place by states to show that they were being good faith actors complying with those federal enforcement provisions. If the federal government cares less about those, we might not need that litigation. States simply might change their rules and say, we're thrilled to be the provider of marijuana to the rest of the country. Marijuana can be purchased here by out-of-state people and may be carried out of state without violating state laws. And then, Rob, we really will see how much the federal government cares about the interstate trafficking, because as you rightly point out, it doesn't matter whether the marijuana moves for purposes of federal law, but the states may have an interest and may press the federal government to avoid shipment through states of products that are banned in those states.
And so I'm going to turn to, we only have a few minutes left, unfortunately, but I especially want to get to some of the thoughtful questions I saw in the Q&A about research. One big talking point for quite a long time, and I think rightly so, expressing concern about marijuana status as a Schedule I drug, is that it restricted in a variety of ways the ability for a range of entities to engage in significant research, whether focused on potential medical applications or in other respects. I know there was a federal bill that tried to loosen some of that up even before we got into this latest rescheduling space. I've seen various conversations about now that might be a new barrier rather than a new opportunity. But to the extent, and I think rightly so, that we're concerned about FDA approval and the need for better research to support medical applications of products in these spaces, are we going to get more of that? Is the only way we get more of that is if we get a lot more guidance from DOJ and others, or maybe this is the right way to say it. If it really was the goal of policymakers, either at the state level or at the federal level, to make sure we have a lot more good research about cannabis, especially vis-a-vis medical applications, but also writ large, what could be done now that would help that along? The uncertainty certainly doesn't help, I sense, and I suspect there may be a handful of first movers who will try to push the envelope about research possibilities involving plant touching activities. But I'd love to hear your takes on if this really is, and I think rightfully so, part of what we need to do better on. Facilitate a regulatory structure that makes it easier for legitimate researchers to do legitimate research. I suspect you're not going to say we've gotten there already, but what could be done? What could we be hopeful for to move forward in this space?
I'm happy to answer that question. I would say that you definitely touched upon one of the most difficult things of being a regulator in cannabis, right, is the federal illegality and the lack of overarching federally funded research. I would say that from the division's perspective, right, we had hoped that, with the rescheduling, that would open up that research and that we could rely upon some of those studies. And frankly, it kind of dovetails perfectly with the Dormant Commerce Clause issue. And that what we are concerned about as regulators is that there's going to be a race to the bottom, right, to essentially create a market with the least amount of regulations. And unfortunately, right, so much of the legal challenges that folks face for some of the regulations is due to the lack of research. And so it's kind of created this unfortunate vicious cycle where we don't, necessarily have the scientific backing for some of the regulations that are otherwise in place in other industries. And so, I would say that ideally we would see more of the research. And again, I don't know from the state's perspective, right? We encourage that. We have rules that allow and encourage testing laboratories as well as scientific research to obtain cannabis and have certain procedures in place. But ultimately, we recognize that realistically, a lot of it comes from a funding necessity, and we don't have that. But Kat, I don't know. I don't know if you have thoughts on that, and it seems like you have probably discussed this extensively as well.
Yeah, thanks, Catherine. I want to point out that there have been some changes in the order, some direct reference to research in the order, and that the order has language that seeks to clarify that researchers won't face civil or criminal liability for the sole reason of obtaining their marijuana from a operator, so long as, and this is the new part, so long as that operator has a valid registration at the time of transfer. So this provision I'm interpreting is intended to create a mechanism whereby researchers would be able to access, handle, put their hands on marijuana coming from state medical marijuana licensees. Now that researcher still has to have a DEA registration, and I'm assuming that it's a Schedule 3 registration, not a Schedule 1 registration. But part of the issue that Doug was referencing earlier is that law that was supposed to go into effect created marijuana specific research requirements. And so now it's no longer about whether and where marijuana is scheduled. These research provisions continue to apply and are not changing. The question that I've got is like, well, what does this mean practically? And I think part of the main barrier that remains is that, one, funding, but the type of research that people are actually trying to do are clinical trials. And in order to do clinical trials where you're actually distributing cannabis to patients, you have to get FDA approval for an investigational new drug. And these products do not have that. And so I do think that there are still going to be barriers to many different types of research, particularly the type of research that might be necessary for there to be specific treatments or indications. And I just want to state for the record that specific category of FDA approved drugs containing marijuana, that other category of product that's been rescheduled, there are no products that are FDA approved drugs that contain marijuana. This was essentially the administration and DOJ saying that if there are products in the future that are FDA approved, we're predetermining that these will be Schedule 3 substances. And so I know that I've gotten a lot of questions about, well, what are those specific substances? They don't exist.
Sam or Rob, thoughts on research before we wrap it up? All right, well, then I will just jump in to say thank you to all of our panelists for helping us understand a little bit more where we are and where we may be headed. I'm incredibly grateful to all the attendees and the folks who shared questions both before and during the panel. Obviously, we couldn't address everything, but I think we did a wonderful job of sort of covering the landscape as we know it. I also would encourage all of you on the panel, but also those in attendance, let us know. I think we'd like to do another one of these after we have the hearing and get some sense of what it looks like and whether it does continue the status quo or start giving us a different vision of where we're headed. I'm not even going to try to address one of the last questions which was, hey, what would be the best policy we could have to map this out over the next 5 years? I think we've seen, and this order even reflects, the way in which a range of unpredictable politics end up shaping the way in which our cannabis laws and practices move forward. But I am, again, just incredibly grateful to all of you for helping us make the best of it. And if anybody wants to add 1 minute of a last word, they're more than welcome to. But again, thankful for everybody's time and grateful. I've certainly learned a lot. Hope everybody in attendance has as well. Thank you all. We'll be back at you hopefully soon. Please let us know. And again, great thanks to the folks at the Drug Enforcement and Policy Center, Holly especially, for getting us up and running. There's some links in the chat, and this will be available on a recording in the coming weeks. And so thanks again. Please check out all the other videos we've also done, trying to make sense of what's not quite sensible, but hopefully not nonsensical in this world of cannabis law and policy. Thank you so much. Again, grateful to everybody. Really enjoyed the conversation.